In fact, there were no injuries consistent with a motor vehicle impact on Mr. O'Keefe, correct?
That's huge. That should be not guilty right there, to be honest with you.
Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. And what he do? And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, your board-certified criminal defense lawyer, here at your service with my Pearl handle pistol cufflinks, so graciously gifted to me by our former content genius that you and I knew as Michael Rivers, God rest his soul. Today we're reacting to the medical examiner's testimony on the Karen Read trial. And we're going to get into this kind of in detail. It's not going to be an overview, and it's going to be kind of what you look for when you cross-examine a medical examiner. But before we get to that, this is brought to you by AskALawyer.com. AskALawyer.com is a very effective way to find out if you have a case. If you have something that's nagging you, I just really hate that son of a bitch. I really want to sue him. Do I have a claim against my father because he's such a dick, or my grandma because she's in my basement and I can't get her out? How do I get her out? Well, what do? You go to, for $49, you go to AskALawyer.com and you try to get the answers that you need. You could say, I don't have a case, now I have peace of mind. Or I do have a case, what's the next step? Or if you want to do your own legal research, because you're your own lawyer and you're the smartest guy in the room, so what do? You got the AI component for your mom. No. So if you want to be your own lawyer, AskALawyer.com also has an AI component, which is trained on all the 50 nifty United States and all the laws. So do your own research and go to AskALawyer.com. They have live lawyers standing by for $49. It's a great value. Same people that brought you eForm and eSign. Fantastic folks. Really solid, loyal sponsors of the channel. So give them some love because they're giving us love. All right, Karen Read, get drunk, 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 get drunk. Nothing good happens after midnight and going to the bar, then going to another after party. Honestly, I've never been to a fucking after party, and I will never go to an after party. I'll have a couple drinks, I'll have some fun, but then I'll get in my Uber and go home. And guess what happens after that? No drama happens after that. Karen Read put herself in a pickle. And now she's on trial. They're in like the 5th week of this trial. Why is it taking so long? This is the second time. I can't imagine what her legal bills has got to be. So what we're going to react to today is some testimony of the medical examiner and kind of do an overview of what the injuries to John O'Keefe were and what this all means legally. One of the things that the defense has going for it is, there's two things. There's the cause of death and the manner of death. All right? The cause of death, as we will know, is blunt impact injuries of the head and hypothermia. That's the cause of death. The manner of death is undetermined. What is manner of death? Manner of death is when you have like either a homicide, suicide, accident, natural causes, that kind of thing. And in this case, the medical examiner can't determine the manner of death. So the medical examiner cannot say it's a fucking homicide. That's a problem for the state. Before we get into the photographs, and I'm going to warn you right now, they're kind of graphic. They're not as bad as I've seen. So, for me, it's not that big a deal. But if you're squeamish, take a sip of your red wine, grab a big thing of popcorn, and don't spill the wine into the popcorn because it might look like some of these photos. Yeah. Why do you have to blur them? Why? They're not that graphic. For reasons unknown to me, we can't show you the actual images, but I'll comment on them and then we'll give the link here so you can look at them yourself. So if you look at the back of his head, he's got a laceration at the back of his head. If you look at his, what is that? That's his right arm. Or right hand, he's got bruising on his right hand. You look at his left hand, he's got some other bruising marks on his left hand, which could be defensive wounds. And you also bruise when they put a IV in you too, and I don't know if any of that's related or not. But then look at his freaking arms. His arms have got lacerations. They've got what really almost look like dog bites, and they don't look like they're consistent with being dragged or being hit by a car. And you got a couple of like big lacerations. I mean, they almost look like they're, the equidistant from a couple of canine teeth, don't they? Yeah. So that is the precursor before we start listening to this testimony. Now, this is about 20 minutes long, and so I'll comment on it along the way. You've got hypothermia and blunt force trauma, basically. And we're also going to get into one more piece of evidence, and that is the cell phone data, which, I mean, these cell phones, remember what I told you about the digital footprint? It just shows you everything, when it was last used, when it was moved, the temperature, all these different things that can give you a lot of information that you can draw conclusions from. So let's get into the testimony. This is the cross-examination of the medical examiner in the Karen Reed trial.
Isn't it correct that for hypothermia and the presence of Wisniewski's ulcers or spots, that you have to have a predominance of the stomach covered by the spots for them to be Wisniewski ulcers?
All right, Wisniewski. So that's a new one for me. I don't know what the fuck Wisniewski is. Let's look it up together. Okay, I don't know what the fuck it is. Let's look it up. Wisniewski spots are something that happens during hypothermia. They are also known as ulcers. They are gastric mucosal lesions that are often associated with hypothermia, especially in cases of fatal hypothermia. And that's one of the causes of death that we have here. One of the things you have to do as a defense lawyer, and I've not had a death caused by hypothermia, because usually my deaths are homicides that are like, shootings or stabbings or something like that, or car accidents. But you have to know the subject matter, and you have to study it, and you have to know it as much as the forensic pathologist that you're cross-examining. That's just to give you a little background as to what he's talking about.
I think there's different levels and different grades.
In hypothermia, particularly death from hypothermia, wouldn't you expect to see a predominance of those ulcers, meaning they take up most of the stomach lining? Isn't that what you would expect to see?
Not always. I have seen that. I have also seen cases with much fewer spots, as you refer to them.
But isn't the majority of the cases that you have seen where someone has actually died from hypothermia that the ulcers predominate, take up greater than 50% of the stomach?
No, he doesn't know the answer to that question. He doesn't know what she's going to say. He's already asked her once, and she's not really coming along with him.
Yes.
Oh, he was right.
And what percentage of the, and I'm trying to avoid putting it up again, so what percentage of the gastric mucosa of Mr. O'Keefe would you estimate is taken up by the ulcers that you have identified?
I would say somewhere between 10, 15%.
Just 10 and 15%. Thank you.
So he sort of shot him. I don't know. He didn't really shoot himself in the foot, but she didn't make the point that he was trying to score on.
Now, if we could look to the issue of continuing with hypothermia. Let's go to frostbite. Do you note any evidence of frostbite on the deceased, Mr. O'Keefe?
It's hard to hear there. He said, did you notice any evidence of frostbite on the decedent. And that's instructive because the issue of frostbite is important because it goes to how long somebody might have been exposed to the elements.
No, I did not.
Do you know what the weather conditions were in Canton, New York on the early mornings? I'm sorry, I keep saying Canton, New York. My apologies. Do you know the weather conditions in Canton, Massachusetts?
Do you know the weather conditions in Canton, Massachusetts?
Starting at midnight on January 29th, 2022, going through 6 a.m. on January 29th, 2022.
So one of the things a medical examiner does is they don't just look at the body. They look at everything. They look at the circumstances, the police reports, interviews, the weather conditions, the scene. They take a little bit of everything or take it all in, and that's how they draw their conclusions.
It was very cold. There was a blizzard coming.
They called it a nor'easter, right?
Correct.
And when you say very cold, in addition to very cold, do you recall whether there were gusting winds?
I believe so.
And do you understand that when there's a very cold temperature in Fahrenheit and you add gusting winds, that is called, when you apply the two together, that's called wind chill, right?
Correct.
And with wind chill, doesn't the phenomenon of wind chill mean that the wind combined with the temperature brings the actual temperature down, and in addition to bringing it down, temperature in a wind chill calculation, it also has a physical effect on the body, correct?
Well, of course, colder temperatures are going to have an effect on the body. And his point is, you didn't see any evidence of frostbite. And you have a nor'easter, you've got a blistering blizzard conditions, and if he was out there for that long, you would have evidence of frostbite, is basically what he's saying. So the temperature that night was anywhere between 12 and 24 degrees. And it could have even been lower with the wind chill.
Wind chill. Doesn't wind chill also cause greater effects than if there was no wind?
Correct.
So in medical terms, the wind synergizes with the temperature and exacerbates the effect on a human.
Correct.
And with a wind chill, isn't it correct that you would have a greater chance of frostbite than if there was no wind chill effect at all?
Yes.
So, you saw no signs of frostbite on Mr. O'Keefe, correct?
At the time of my examination and at the time of autopsy, no, I did not.
Did you see frostbite at any other time with regard to Mr. O'Keefe?
I only examined him at the time of autopsy.
So at the only time you examined him, which is at the time of autopsy, you had zero signs of frostbite, correct?
Correct.
So you just asked that same question 3 times. And that's a tactic because, I was in a trial not that long ago where the prosecutor kept, he would tail off, and at the end of the question, he'd ask the same question over and over again. And that's part and so-and-so, right? Yeah, and then you did this and you did that, and that was part and so-and-so. Finally, I said, objection, Your Honor, for the 3,000th time. Asked and answered. He said the same, because he kept trailing off. But it's effective because you're repeating the same message over and over again. And his point is basically this. If he would have been out there for as long as everybody said that he was out there, he would have been had skin damage from frostbite.
Dr. Scordi-Bello, now that you have gone through this part of your examination here today, would you like to amend in any way your opinions as to whether hypothermia was any cause of the death of Mr. O'Keefe?
No, I don't. I still believe that there were hypothermic signs.
Hypothermic signs, correct?
Yes.
So when it comes to the cause of death, you can have contributing factors. You know, one thing might not be the sole factor, but it can be a contributing factor. So you can have multiple things that have, you know, a substantial effect on the death of an individual. This is why this is important. He was dropped off supposedly at around 12:30 and then wasn't found till about 6 hours later. And if he'd been sitting out in the blistering cold for 6 hours, you would expect some evidence of frostbite, some evidence of, you know, more damage to the skin than there was.
I'd like to move to another topic area, please. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you?
No, I did not.
That's incredible, because you know what the case is about. You know that he was dropped off by somebody. You know what the police are talking about. And she doesn't even opine as to whether or not a vehicle struck him or not. You know, that is incredible, because that's what the whole case is about. And if you got a medical examiner who never even opines on whether or not somebody got hit by a car, and it's a car case, what does that say for the state's case?
In fact, there were no injuries consistent with a motor vehicle impact on Mr. O'Keefe, correct?
Sustained.
That's huge. That should be not guilty right there, to be honest with you. I had a case once where my client and his brother, oh my God, my client's brother smashed his girlfriend in the face with a baseball bat and killed her. She just killed her with this baseball bat. And then he calls my brother, hey, I need your help, blah, blah, blah. So they put her in the back of a truck on a motorcycle, strap her to the motorcycle without shoes on, get going about 50 miles an hour, and then dump the thing out on the roadway to make it look like she, you know, was in a motorcycle accident. And let me tell you something. You know, these people are trained. They see this stuff day in, day out. They know what kind of, you know, imprint a steering wheel leaves on the chest. They know what kind of injuries you have when you have trauma from a motor vehicle accident. And they've been doing it for a long time. And there's also literature on it. And they rely on that. So let's see what she has to say. Oh, by the way, in that case, my clients were fucked.
Did you evaluate it all in your autopsy whether Mr. O'Keefe had any injuries consistent with a motor vehicle accident? Objection.
I'll allow that.
I don't know what's the objection there. I mean, that's totally permissible, and the judge is allowing it. Let's listen.
Yes, I did examine his lower extremities. That is protocol in any case of suspected impact with a motor vehicle. So I did examine his legs, and I did not see any evidence of an impact site.
Do this with somebody that you love. Stand behind a car. You know, where does the bumper come up? It doesn't come up to your chest. It doesn't come up to your arms. You know, I mean, unless you fall over and you hit your head and then you get run over. But there wasn't any of that in this case. I mean, if you're standing behind the vehicle and the bumper hits you, you're going to have trauma to your legs.
And could you elaborate to the jury what you mean by no evidence of an impact site? Objection.
I'm going to sustain that objection.
Why is that objectionable? That is absolutely permissible. Can you explain to the jury what you mean by no evidence of an impact site?
What do you mean in your answer, no evidence of impact injuries?
I'll allow that.
All right, I see what she's doing. So maybe it's talk directly to the jury. We don't have that rule here.
What I look for is some sort of bruise either on the outside of the leg or bleeding on the inside after the skin is reflected in the soft tissues, or any fracture of the bones of the legs. I did not observe those things.
That was going to be my question. You did not observe any of those things, correct?
Correct.
So you didn't notice any fractures to his metatarsals, his feet, right? Or his toes or his ankles, correct? You didn't see any fracture to the tibia or the fibia, correct? You didn't see any fractures to the patella or the femur, correct? And you didn't see any fractures to his hip cradle, right? And you didn't see any bruising from his toes up to his hips, correct?
I'd like to turn to, please, the face of the decedent in your analysis that you discussed on direct examination of that area of the decedent.
Now remember, he had a laceration to the back of his head. He had other wounds about his head and neck and his face, which would be consistent with getting your ass kicked.
You talked about ecchymosis. You recall that?
Yes.
In medical literature, there's a synonym for ecchymosis. It's sometimes referred to as raccoon eyes. Is that correct?
Guess what happens? How do you get raccoon eyes? You break your nose.
Ecchymosis doesn't cause a laceration to an eyelid, does it?
No.
Ecchymosis does not cause a laceration to a nose, does it?
There was an abrasion on the nose, but no, the answer is no.
Yeah, there's a cut across his nose. Take a look at those pictures. And guess what? You punch somebody in the nose, you can cut their nose, and then all of a sudden you get the black eyes.
Correct. So ecchymosis doesn't cause a laceration to the nose. Correct?
Correct.
Did your report at all evaluate whether there was any significance of the laceration to the eyelid that you spoke about in your direct testimony?
What do you mean?
Other than just noting that there was a laceration to the eyelid, did your report at all evaluate the potential significance, if any, of that laceration to the eyelid?
I noted it and photographed it, and it was part of the totality of the blunt impact injuries that I noted on both the face and the head.
Do you believe that the laceration to the eyelid could be caused by a blunt impact injury?
A laceration, by definition, is a blunt impact injury.
The question was, do you believe that the laceration on the eye is caused by blunt? And that's what she just opined on.
Do you believe the eyelid laceration was caused by a blunt impact injury from falling backwards and hitting one's head?
The question was, do you believe that the laceration in the eye was caused by a blunt force trauma, basically by falling back on the head? And she's going to say no.
Not from falling backwards and hitting one's head, but that area at some point came in contact with a blunt object or surface.
Okay, if I could follow up on that, please. So you agree that if a person falls and hits the back of their head, that they cannot sustain an eyelid injury, is that correct?
Correct.
All right. And if somebody falls backward and hits their head, they can't sustain, from that impacted back of the head, a laceration to the nose, correct?
Correct.
But if you're getting your ass kicked and somebody's punching you in the eye and punching you in the nose and you fall back and hit your head, you know, of course, that can cause your death. I had a case years ago where my client was at a bar and some other guy was being really disruptive in the bar. My client was asked to help get him out of the bar. And so my client and another guy grabbed him from behind. My client had his hands and were escorting him out of the bar. He was drunk. And so he wriggles free. He's about to take a swing at my client. My client just pushes him. He falls back, hits his head. That's all that happened. It was cold. It was icy. It was below zero in northern Minnesota. He falls back, hits his head, never wakes up, and dies 5 days later in the hospital. And they charged my client with second-degree murder. And he was acquitted in, a half hour. It was so overcharged. But, and I think that's where the lawyer is going with the cross.
So if we could, Mr. Wolk, and with Your Honor's permission, publish which is already in evidence, which are depictions. Let's start out with, please, the laceration to the right eyelid.
Take a look at that.
And Dr. Scordi-Bello, is this the laceration to the right eyelid that we've been talking about of Mr. O'Keefe?
Yes, it is. Yes, it is.
And that injury could not be caused by a fall backwards and one hitting their head, correct?
No.
I'm sorry, we'll just need, and then I'm going to repeat the question. Can you state your answer again? Let me that injury to the right eyelid, that laceration, could not be caused by someone falling backwards and hitting their head, correct?
Correct.
Bear with me one moment, Your Honor.
Now, this is supposed to be Karen Reed running over her boyfriend, right? That's what the case is about. Her being drunk and running him over and either not knowing it or whatever, but charged with second-degree murder. And it's almost like it just came right from there to here. And so the real question in this case is, are the injuries that John O'Keefe suffered more consistent with a car accident or deliberate, being run over by a car, or are they more consistent with getting his ass kicked and having a dog bite him?
May I approach, Your Honor?
Yes. Show Mr. Brennan.
Your Honor, I erroneously assumed that that picture was in evidence, and I would like to now properly lay the foundation if I could.
Okay.
Dr. Scordi-Bello, you see what's in front of you.
He just published an exhibit to the jury. See, you can't show the jury anything that's not already in evidence. And so what he did, he probably put up a picture, realized it wasn't in evidence. Now he's got to go back and lay foundation. And is this a picture of, did you rely on this? And did you take this picture? And does this resemble the condition of the body at the time you took the picture? And blah, blah, blah. Your Honor, I'd like to move to admit Defense Exhibit D 1783.
Can we mark this?
So, Mr. Brennan, are you objecting to that coming into evidence? Okay, so let's just put it in evidence.
Exhibit 165.
Thank you.
Yeah, Your Honor.
Yes.
Thank you. Dr. Scordi-Bello, I place before you what is in evidence now is 165. And Your Honor, may I have Mr. Wolk publish
Yes.
165? Thank you, Mr. Wolk. So, Dr. Scordi-Bello, that laceration to the right eyelid could not be caused by a fall backwards where someone hits the back of the head, correct?
How many times has he asked that question now? I mean, if I'm the prosecutor, I'd say asked and answered, move on.
Correct.
So that injury, you've called, what do you label that category? Traumatic, did you use that phraseology?
Blunt
Blunt
impact.
impact. So that's a blunt, in your opinion, that's a blunt impact injury, correct?
Correct.
So is it correct that that injury had to occur in some manner other than falling backwards and hitting one's head?
Yes.
And is that injury consistent or inconsistent with a punch?
I'll allow it.
What's the objection there?
Your Honor, I object!
And why is that, Mr. Reed?
Because it's devastating to my case!
Overruled.
Good call!
Is she speculating? Let me tell you something. She's an expert. She can opine. That's the thing. A layperson can't speculate. But based on my training and experience, it is consistent.
I'll allow it.
Could be consistent.
That's huge. And that's the state's expert. One of the things about a medical examiner is that they're about the science. And when we ultimately wind up doing our podcast, I'll have Lindsay Thomas on. She was one of the medical examiners in the George Floyd trial. She's a good friend of mine. I've used her in a lot of cases. She's just amazing. But they don't have, generally speaking, they're not supposed to have an agenda. They're not an arm of the state. They take the facts where the facts lead them.
If we could, Mr. Woke, have the laceration to the nose.
I like what he's doing here. He's going through the injuries, and he's going to say, are these consistent with, a punch or an altercation? She's going to have to say yes. And then he's probably going to go to the hands and say, now look at his hands. Are the hands consistent with defensive wounds?
166.
Oh, thank you.
May I, Your Honor?
Yes.
Thank you. Dr. Scorti-Bello, I have put before you what is in evidence is 166, and Your Honor may, Mr. Woke, publish.
Yes.
Thank you. Dr. Scorti-Bello, does that exhibit fairly and accurately depict the laceration to the nose of Mr. O'Keefe?
Yeah, it's an abrasion. I described it as an abrasion, as a scrape.
So you would classify that as a scrape?
Yes.
That scrape could not be caused by someone falling backwards and hitting the back of their head, could it?
Not by a single event, no.
But you know what could happen? The punch to the eye and the punch to the nose, and then a fall could cause somebody to fall backwards and then hit their head. That's where he's going.
You can take that down, Mr. Wolf. On your direct testimony, you talked about injuries to the right arm of Mr. O'Keefe. Do you recall that?
Yes, I do.
And is it correct that you, in your autopsy report, did not determine the cause of those wounds to Mr. O'Keefe's right arm?
Now remember, those were they look like long cut marks, or they're equal distant, and I don't think there's any evidence in this trial that there's either a tool or some other piece of metal or anything from the car that would match those marks. It sort of does look like he got the shit bit out of him by a dog.
That's correct.
With Your Honor's permission, I would like to...
One of the things you can do is you can go and meet with the medical examiner before trial and say, I want to ask you a question about this. And you can kind of go through some of the things that she'll agree or not agree to. And then when you get to trial, then you look like you got your shit, together. And if you can say, hey, look, these look like dog bites, don't they? If she'll go along with that.
Your Honor, Mr. Brennan has agreed to
Okay.
stipulate into evidence these two photographs. May I please have them
Yes.
marked as next in evidence?
Exhibits 167 and 168.
Thank you.
I'm going to do the same thing, if I may, Dr. Shorty-Bello. I'm going to leave these with you, but I'm also going to, with the court's permission, have them published.
Okay.
Use whatever one best allow you to answer the question. Your Honor, may I have Mr. Wolf publish those two? Thank you.
You got a small town, low tech courtroom.
With regard to what is on the screen, am I correct that you noted these injuries and these wounds to Mr. O'Keefe in your autopsy report?
Now take a second and go over to the link for 2 seconds. Put me on pause. Go to the link. Now look at the arm that he's talking about so you can kind of have a better idea what her testimony is going to be. Okay, thanks for coming back.
Yes,
And am I correct that you noted that there was a pattern to those wounds?
correct.
And although you noted there was a pattern to the wounds, you were not able to determine the cause of those pattern wounds. Is that correct?
That's correct.
Are those injuries consistent with a dog bite?
Based on her answer to the last question, ask something else.
I'm sorry, I couldn't hear you.
Ask another question. Sustained.
So he needs to lay foundation.
Can you identify any cause of those injuries that would be consistent with what is depicted on the screen? Objection.
So, can you answer that, Doctor?
I cannot.
You can take that down, Mr. Wolf. Thank you.
Basically, she's saying, I have no idea how those marks were made on his arm. So I can't say they're consistent with the dog bite, which doesn't really help the defense too much.
Do you recall discussing at all on your direct examination? Well, let me ask it this way. Did you evaluate at all in your autopsy a gray hoodie sweatshirt of Mr. O'Keefe?
No, I did not.
So,
That is a little bit of an issue because if you look at that gray hooded sweatshirt, if it has puncture marks consistent with a dog bite, why wouldn't you look at that? Even pictures.
were you aware that there was clothing associated with Mr. O'Keefe when he came as part of the autopsy?
He did not have any clothing that came to us. The clothing was removed at the hospital and was packaged and I believe submitted as evidence.
So the clothing of Mr. O'Keefe, a t-shirt or a hoodie, didn't make its way to you?
No,
So the clothing of Mr. O'Keefe never made its way to the medical examiner, which I think is a mistake.
You were unable to reach a determination as to the manner of death of Mr. O'Keefe, correct?
that is correct.
So you had doubts about the manner of death of Mr. O'Keefe, and you consider those doubts reasonable?
Sustained. Sustained.
That's not a proper question for her. I mean, he's trying to backdoor into the province of the jury. The better question would be, you cannot tell within a degree of medical certainty the manner of death here, can you? And then you argue in your closing that reasonable doubt and beyond a reasonable doubt is a higher standard than the medical standard.
You were not able to reach a determination as to the manner of death of Mr. O'Keefe, correct?
Correct.
And manner of death, as you've testified, includes the circumstances surrounding death in addition to the medical analysis that you performed. Okay.
So the last question was, the manner of death includes the circumstances within which somebody dies, including the medical evidence. And she just answered yes. So take a look at those pictures. It looks like he was hit in the face and then hit the back of his head, and then something happened to his arm. I had this in a case not that long ago where the defense and the state's medical examiners couldn't determine manner of death. And the jury still convicted my client anyway. I just couldn't believe it. If there's a doubt that the medical examiner has, how can a jury not have the same doubt? You know what I mean? There was some other evidence in that case that was pretty bad. So I can't control every aspect of what's going on, and neither can they in this. But in this case, I think it's instructive that there's no other trauma except for the trauma to the head and the marks on the arm. And then you couple that with his cell phone data that shows the temperature around 50 degrees. The data that was a state trooper, Nickolaus Garino, testified on Thursday that the data that he extracted from O'Keefe's phone shows that it remained where his body was later found on the front lawn at 34 Fairview Road from 12:25 until 6:15 a.m., so 6 hours. The cell phone data would be consistent if he's in the driveway or if he's in the house. It's not gonna move that much, and it certainly wouldn't change cell phone towers. So, there's some reliability issues, I guess, with regard to the temperature data and the health data, like where he was at the time and whether he was walking up and down stairs or not. But I think the bigger picture here is he's got what looks to be a punch in the eye, a punch in the nose, and a laceration to the back of the head. In other words, he got hit, he fell back, he died. And what he doesn't have is injuries consistent with a car crash, or being run over by a car. He just doesn't have it. And he's got no frostbite. I guarantee you, you're out for 6 hours in the blistering cold. You're going to have frostbite. You're absolutely going to have frostbite. You're going to freeze. So that's our little, I don't know what to tell you. I'm on the side that it's not proven. Now, keep in mind, defense doesn't have to prove anything. They have an LA doctor that's going to say that the bite, or the marks on the arm, are more consistent with a dog bite, and that's going to be their. And guess what happened to the dog? The dog fucking was sold. The dog's no longer available. Just do any analysis. Gee, big surprise there. What if we find out that the marks on his arm were consistent with the canine teeth of the dog? That would be incredible evidence. There's all kinds of evidence in this case. It just doesn't make sense. You see him in the footage in the bar. He's not wearing a jacket. EMTs say he was wearing a jacket, or paramedics, whatever. And if he was outside that whole time without a jacket, he'd be frozen solid. What we have in America is either guilty or not guilty. We don't have innocent. We don't have not proven. We just have guilty or not guilty. And the state has to prove their case beyond a reasonable doubt. Not up to a reasonable doubt. Beyond a reasonable doubt. A reasonable doubt is described as the kind of importance one would use in your most important affairs, the care you would use in your most important affairs. Okay, that's what reasonable doubt is. Based on reason and common sense, and not based upon a fanciful or capricious doubt. Can you tell I've read that jury instruction about 1,000 times? It's not just up to a reasonable doubt, it's beyond a reasonable doubt. And how far beyond that is up to the jury, because there's no instruction on how far beyond it is. So we'll continue to follow the Karen Reed case. I just wanted to do a quick, I had come across this video of the medical examiner, and I just thought it was interesting that we just don't have, crash wounds on this guy. And it really does look like he got his ass kicked and died from a head injury. That's what it looks like to me. And when you have a medical examiner that can't determine the cause of death, how can a jury supplant their judgment for the medical examiner? So we'll see you next time here on Criminal Lawyer Reacts. I'm Bruce Rivers, your board-certified criminal defense lawyer. Make sure you subscribe, follow us on Instagram, follow us on Twitter, sign up for Patreon, go to clrbrucerivers.com for all your merch needs, and we'll see you next time on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, please just at my God.